Buckle up, folks, because this isn't your average day in court. We're stepping straight into a Texas divorce courtroom where the drama doesn't just enter with the parties. It explodes before the case even gets underway. The judge barely has time to call the session to order before chaos erupts. Custody evaluations are demanded, drug tests thrown on the table, and even a psychological exam requested. Ms. Stiles is already scrambling to get herself removed from the docket, but the judge cuts her off cold. She will be coming off, one way or another, and most likely not in the way she's hoping. And believe it or not, this is just the opening act.
How are y'all?
Morning, how are you?
Morning.
Are we waiting on anybody?
No.
Okay, what can I do to help y'all today?
Yes, sir. Get us off of your docket is what you could do. Go ahead, Lacey. Start talking.
That's pretty specific. Miss Kimball?
Yes, sir. Specific.
Go ahead, Miss Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah,
And
blah.
stop talking. You'll be able to respond in just a second. Miss Kimball, you can go ahead and finish, and then Miss Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one.
The tension hits a breaking point as Ms. Kimball lays out how discovery requests were flat out ignored. Yet Ms. Stiles just can't help but interrupt. The judge fights to keep control, but the real shock comes when the drug test question lands. Without hesitation, Ms. Stiles drops a bombshell. She smokes marijuana every single day and insists California law has her back. One tiny problem. The giant flag hanging behind the bench screams Texas, where weed is still very much illegal. In an instant, this courtroom battle shifts into overdrive.
That's not an option. There's nothing there, unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me. Or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out, as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions, and then we ultimately never got a response, and she filed a motion.
She got plenty of responses.
The judge zeroes in on her marijuana admission, but Ms. Stiles quickly shifts gears, flat out refusing a psychological exam and insisting the court has no power over her. What she doesn't realize is that in a custody fight, the court's reach runs deep. Her bold defiance doesn't come off as strength. It looks more like Exhibit A for why that psych evaluation might be exactly what's needed. Patience in this courtroom is hanging by a thread.
How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents and also talking that there is.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So, Ms. Kimball, why don't you just go ahead and finish telling me what? So you said that you're wanting a drug screen, so a drug test, and do you say psychological or psychiatric? I thought you said
psychological exam. And then we have an order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition and for attorney's fees for $1,500.
All right. So, Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front I'll fall for marijuana.
When was the last
But
time?
I'm happy to pay it on
When was the last
expense.
time? you took marijuana?
I use marijuana daily. All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight. So I'm glad to take the direct test.
Stop.
Okay, go. It's going to be on his expense, but I'm
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
I'm
So
fed
you can just,
Kimball.
if you're gonna use
Respect-
my last name, that's fine. Just say Judge Dyke. Okay, it's pretty easy. So you use marijuana all day, every day.
Not really day every day, but I use it daily. If that helps you with your interpretations, Mr. Low-key Honorable Judge tonight.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
I'm not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes,
The judge shifts to the motion to compel. Ms. Stiles cranks up the hostility, dropping a curse word right in the middle of her response. That slip earns her a sharp warning and a new rule. Every swear costs her $100. The judge makes it crystal clear that respect isn't optional in this courtroom, but from her defiant tone and body language, it's obvious Ms. Stiles is nowhere near finished testing just how far she can push the bench.
do you agree or not agree?
You don't get to ask me questions right now. I'm asking
That's
your position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I would propose.
And whose expense? Mine? Because if it's mine, I'm not fucking doing it. Sanction, give me $100 fee. Woo
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're gonna want.
Stop. That's not something that she asked for. Ms. Kimball, what date?
No,
What date?
everybody else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting? how long? That's a valid question. Is it half day, an hour, 2 hours? What do you anticipate?
I would anticipate a full day.
Okay.
So what, the
Ms.
30th or the 2nd?
Which of those dates works better for you, Ms. Styles?
What time?
When deposition dates come up, Ms. Styles can't resist. She drops another profanity on the record. Instant contempt, another $100 fine. Her sarcastic jabs make it painfully clear she has no clue how badly she's sabotaging herself. The judge's patience is running on fumes, and with every reckless word, she edges closer to being crushed by the full weight of the courtroom.
That is 3.
Yep.
Supposed to start at 9 a.m.
What date?
So that question is to you. Never
I
mind.
said what
I'm
time?
not gonna let you
Time,
pick.
date? You know, these
I'm not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that.
The judge calmly offers 2 deposition dates, but Ms. Styles snaps back with, "What time, dumbass?" Her third contempt on the record. She's instantly muted, but not before flashing the judge a middle finger on camera. The case rolls forward without her input, leaving the courtroom stunned. It's self-destruction in real time, and impossible to look.
As another violation. So, in terms of the request for the deposition, she didn't have any objection. I don't know for my own record that she opted out after.
Next. With Ms. Styles gone after her meltdown, the judge marks for the record that she chose to bail mid-hearing. The case pushes forward without her, a brutal reminder that storming out doesn't freeze the process. It only silences your own defense. And that's where this roller coaster ends. If you enjoyed the breakdown, hit like, subscribe, and stay tuned for the next courtroom showdown.